Welcome to HH Law. I am John Henderson along with Price Sigal. We are here today to talk about drugs and drug charges in South Carolina. Price, thanks for joining us.
Thanks for having me.
All right. We are going to talk separately about marijuana at the end of this video because it's sort of in a classification in and of itself. But the appropriate place to start with any and all drug charges is the schedules. Explain to us what we mean by the schedules.
The schedule is just the classification that the legislature put on each and every drug. Certain drugs are in the same schedule with another. For example, fentanyl, meth, cocaine, those are Schedule 2. Heroin, Schedule 1, along with marijuana. So the legislator has put these into schedules. It doesn't necessarily mean they're going to have the same penalty, though. It's just a way that they've classified them.
Okay. And so when you're charged with a drug crime, or you think you may be charged with a drug crime, they're classifying these things into different schedules. Then we jump to, all right, what type of drug? But then we are jumping straight into what are the charges? And there are various charges. People hear them a lot. It's like simple possession. Then there's possession with intent to distribute. And then there's trafficking. Let's take those one by one and kind of what are the elements? What are you looking at in each? Simple possession.
So with simple possession of any drug, then what you're looking at is a certain amount of drugs found on a person or in a person's vicinity or dominion or control. And it's a certain amount of weight. We call it an inference weight. So for example, with marijuana, 28 grams is the inference weight. If it's above that, then it goes to the next level, which is possession with intent to distribute. So anything 28 grams or below, which is the inference weight, that means that it's in the category of simple possession. That's important because when you're in just the possession category, the penalty is lower. If you want to look at, let's say, meth, for example, if you're just charged with possession of meth, that's a 0 to 3 year charge. However, if you go over the inference weight, which is set by the legislature, then you're looking at a charge of possession with intent to distribute meth. That makes the penalty jump up. So the first one is possession. That's the lowest level. All possession levels have a 0 floor, which means that you could get anything from time served all the way up to however many years in prison. The possession with intent to distribute, some of those have a 0 floor, but some have a mandatory minimum, which means if you get convicted, you have automatic jail time from the start that you have to serve. Possession with intent to distribute is the middle level. Sometimes you can be charged with that simply because you're found with drugs over the inference weight. Sometimes you can be charged with that because you're found with a small amount of drugs, but you're also found with a scale, baggies, cash, or any other indication that you're dealing. So it doesn't necessarily have to be over the inference weight. You can also be charged with the possession with intent to distribute if all you have are the drugs and none of the other stuff, if it's over the inference weight. So those are kind of the nuances. And then you have trafficking. Trafficking just means that they think you're basically dealing at a higher level. All the state has to prove with a trafficking charge is possession and weight. They have to prove that you are possessing it either on your person or within your vicinity or control. And also you have to prove the weight. So actually trafficking is a pretty easy case for the state to prove because if they can prove possession, the weight's, really easy. So ironically, the hardest one for the state to prove is possession with the intent to distribute. And the reason is because they have to prove that you had that intent. It's not as clear. You have to infer it from a lot of different things. So that's actually one that a defense attorney would have the most to work with as far as attacking the state's case.
Yeah, you'd have a lot of circumstantial evidence trying to prove that intent, some sort of
exactly. It's built right in the name of it. They have to prove that was your intent. Whereas with trafficking, they don't have to prove you were meaning to distribute it. All they have to prove is that you had it and it was over a certain amount.
So there are a couple issues that come up with these. I'm curious your thoughts on. First is the search and seizure rules, right? On the Fourth Amendment, law enforcement, any government entity cannot unlawfully search and seize in your house, in your car. What would give law enforcement, sort of trigger them to be able to search your car or your house?
Well, for a car, it's very different from your house. There is an exception to the Fourth Amendment to your rights, and that's called the automobile exception. And that means that if you are utilizing the roadways that are owned and operated by the government, then you are basically giving the government permission to pull you over and check your car for things if you're acting in a certain way. Basically saying, you may own your car, but you're using our roadway, therefore your rights are a little bit different. So for an officer to pull you over using the automobile exception to the Fourth Amendment, they would basically need to believe that you're committing some kind of crime. They pull you over for speeding to start with. And then all they have to do, if they smell weed, then that is enough for them to use the automobile exception to then search your car for anywhere they could possibly find weed, which basically means they can search your car anywhere. If they pull you over for drunk driving and, they think you're drunk, they can use that same exception to search your car for any evidence that you might be drinking or anything that could impair you. So there is a connection between, looking for evidence of the crime that they think is going on, but it's a pretty big exception. And so you have to know that when you're driving on the highways, and they pull you over, that exception can be invoked with anybody. You have a lot more privacy in your house than you do in your car for obvious reasons.
If you smell weed, if law enforcement comes to my door and smells a bunch of weed, can they come in?
Nope, they got to go get a warrant.
All right.
So yes, they can go get a warrant and likely get one if they have good probable cause to give to the magistrate to sign the warrant. And it is a magistrate judge that signs off on these warrants, and they should be laying out probable cause to the magistrate to get these warrants. But yes, that's a perfect example. If they're doing a welfare check and they smell weed, they need to go get a warrant.
So the biggest thing is that law enforcement will ask you questions to try to get into your car. They could ask you questions and you might accidentally consent to your car or your house or something like that. And if they find drugs, paraphernalia, anything like that, then that can enter into evidence.
Correct. I mean, most of the time, if they pull you over and they want to get in your car, they usually ask for consent first, even if they know they have the ability to get in your car through the automobile exception. You can say, no, I don't consent, and then they can use an exception. There's several exceptions to the Fourth Amendment. The automobile exception is just one of them. If you don't consent, then they can still get in another way. If you do consent, then yeah, all of that can be in evidence.
Okay. Let's wrap this up by talking about generally the marijuana laws. Generally, marijuana is sort of classified and treated differently for various levels. We're not talking federal laws here. We're talking South Carolina state law.
Right. So marijuana is in a class of its own. For example, drug charges are what we call enhanceable, which means if you get arrested and convicted for one, and then you get arrested for another one, you're going to be charged as a second offense and then a third offense. With each offense, the penalty gets higher. But the issue is marijuana is different from other drugs. Only marijuana charges can enhance marijuana charges. So if you get arrested for marijuana and you already have cocaine on your record, you're still going to be charged with a marijuana first offense. Same way, if you get charged with cocaine and you have a conviction for marijuana, you're going to be charged with the first offense for cocaine. If you have a cocaine charge on your record and you get charged with fentanyl, that's going to be a second offense. So all drug charges enhance all drug charges except for marijuana. Those are in a class of its own.
And the scheduling has changed on this. In 2021, it went from Schedule 4 to...
Now it's Schedule 2.
Now it's Schedule 2.
And a lot's changing in the marijuana world, and it will continue to change because there's been a lot of states, obviously, that have legalized it, not in South Carolina, but there are different things that are legal, which is making marijuana laws very complicated.
Yeah, and marijuana is getting treated a little bit like Adderall, which is a prescription thing. Also, you can get a prescription for marijuana, in certain states and under certain circumstances that might be treated the same way. If you have more than you're supposed to have, that's how you get charges, or you don't have your prescription.
But I think we'll continue to see changes in the marijuana world. If you're facing a marijuana charge or any drug charge, it can be very complicated because of all these changes. So your best bet is to get an attorney to walk you through it.
Yeah, which means that this video will be outdated. So keep watching the latest information coming out. This is H.H. Law Price. We thank you very much for joining us today to discuss some of these drug issues. We've got more videos, but keep in mind, this is mostly based on South Carolina law. While these ideas and some of the laws apply in other states, they don't uniformly apply. You're going to have to check with your own state and somebody in your local jurisdiction to get more case-specific advice. Thanks for watching.